SJC-13495, Commonwealth v. Quasim L. Hastings.
Okay, Attorney DeMont?
DeMont, yes. Good morning, Your Honor. May it please the Court. My name is Sharon DeMont, and I represent Mr. Quasim Hastings. In 2017, this Court in Crowell v. Parole Board made Parole Board responsible for modifications to its policy in order to accommodate prisoners with mental disability once they're aware of such disability. The Court also said providing an expert to put together a post-release parole plan is such an example to this modification. The Court went on to say that the prisoner with the mental disability is not responsible for asking for such modification and put the responsibility on the Parole Board. Since then, the Parole Board has been fulfilling that obligation by asking the Committee for Public Counsel to appoint counsel to cases such as Mr. Hastings. And counsel, in turn, has been enlisting the help of experts in order to provide Parole Board with such modifications so they can fairly and adequately hear these cases.
And they've been doing that under Section 27B?
They've been, yes.
And so what about, so just tell me what language in 27B permits this?
So the language in 27B, two things. The 27BA essentially puts forth reasonable court cost, extra court cost, which includes experts, and also, as my brother cited in his brief, 27B also says this court cost is allowed with subsequent motions for funding in other proceeding elsewhere, quote unquote. So with those wording in the statute, the court has been allowing for these funds until recently, where they do in some cases and don't in the other, creating a disparity in treatment. Now, the question before this court is essentially whether or not this funding is allowed under the indigency statute. And to that, I'd say this court already answered that question in the affirmative in Diachenko 2, when the court essentially held that it was appropriate to construe that particular statute to...
Can I ask you, Crowell didn't depend upon this statute, right? Because Crowell was a remedy to under the ADA, correct?
In particular, Crowell did not address the funding. Crowell did address the fact that the Parole Board needed to make modifications. The funding was already answered 2 years earlier in Diachenko 2.
With respect to
27B, which is why...
With regard to Article 26, which was constitutionally mandated for juveniles to have this meaningful access to parole, I'm wondering why... I struggle with the words of the statute. Is it one of those situations where we just sprinkle magic pixie dust and say, regardless of the words of the statute, we're going to construe it in order to abide by the ADA and Article 119? Is that what your argument is? Because it doesn't seem like you're looking at the words of the statute. I am, but I don't see your argument as addressing those. Let
me step back and say there are two grounds upon which I am relying. One is the ADA and Article 114, but the other is the right to parole itself. So I say this, in Diachenko, it is true that this court based construing 27B on Article 26, right, based on a constitutional dimension. I would say same thing applies here. Now, there are two different aspects of Constitution. One is Mr. Hastings or cohorts like him that are entitled to a parole hearing and their right to funding to that modification to that hearing.
Can you tell us where in the statute we find this?
So his right to a parole hearing is constitutionally based.
In the funding statute, I'm sorry.
So in the funding statute, right, the wording of the funding statute, I'd say, is twofold. And again, I'm going to defer that to my brother to dive into that because that was mostly his argument. But In the statute itself, this court, it was the same statute that this court construed in Diachenko 2 with the same wording. The wording hasn't changed, but this court chose to construe 27B to include funding for those cohorts in Diachenko 2 based on Article 26, as Your Honor put it.
Now, anytime there's a constitutional right at stake, we should construe 27B to cover the costs for whatever is required to fix the constitutional right.
No.
No.
Only when there is an additional protection under disability. Only when there is an additional requirement based on state constitution, Article 114, and federal constitution, American with Disability Act. So you have a
Well, the
twofold.
ADA is not federal, constitutional.
It's statutory, it's
Okay.
federal statutory.
So when there's a federal statute or a constitutional provision at stake, we construe 27B, regardless of its words, to cover fees, to allow a Superior Court judge to cover the fees.
That's what this court did in Diachenko. Yes. So by
And
that,
there's, and if I said to you, why not limit it to Diachenko 2?
because in this case, there is a mental disability, and mental disability plus the constitutional right to a parole hearing pushes this case over the threshold. And I'll say this. So,
What
Mr.
is the constitutional right to a parole hearing? I thought that was not constitutional.
So here's how I submit we get there, right? Mr. Hastings and cohorts like him, are given a sentence. That sentence is a final judgment in a criminal case. That sentence requires, under the wording of statute, that he shall have a right, second-degree murder, he shall have a right to a parole hearing, not parole, but to a parole hearing after 15 years in this case. That sentencing, those words, gives him a right to a parole hearing that's constitutionally protected by his Fifth Amendment.
So that's my issue.
Right.
Why is that
What-
constitutionally protected if it's provided by statute?
Because if you were to take it away from him, his right to double jeopardy, Fifth Amendment, and post ex facto laws will prohibit the taking away of that right. So this court cannot, as the court has held in cases such as Clay versus Parole Board, Rivera versus Parole Board, that the right to a parole hearing, or not necessarily in those words, but that
You can't change his punishment after it's been
right,
issued.
Exactly. And most recently, I believe in 2023, this court upheld an illegal sentence relying on the same principle. So once he is sentenced, the statutory word says he shall be given a parole hearing. That right cannot be taken away from him without violating his constitutional right to double jeopardy or ex post facto law that's protected by Article 20.
So that may be true, but why is it that the funding comes from 27B? Why isn't it the parole board that has to come up with the funding?
Well, two things. Number one is that, again, in Diachenko, same thing applied, and this court construed the funding to include, construed the statute to include the funding. Secondly, parole board doesn't have the infrastructure. This has been working by the infrastructure, by the Committee of Public Counsel infrastructure that's been in place since the 1980s. They have the ability to disperse these funds after a trial court judge serves as a gatekeeper and can determine whether these funds are reasonably necessary under the guidance of this court in Lockley, setting forth what constitutes reasonably necessary. The word of the statute itself allows for that extra cost and fees to include expert funds, and the committee has a whole department designed for audit and oversight to determine how these funds are dispersed. And it's been working since 1980s.
Why wouldn't your interpretation apply to everyone seeking parole?
It wouldn't. It would apply to people
How's
with
it-
disability.
Okay, that's what I was gonna get
That
to.
is exact. It is narrow.
There's
We're
a
not.
reading that the Attorney General makes, I think, is a little broad, that's gonna open the door for everyone.
Let me be clear. We are not asking to open the door for everyone. I'm asking for Mr. Hastings and his cohorts that have a mental disability that is protected by the constitutional.
Basically, you want us to look at Dachenko and plug in the ADA violation with the Article 26 violation in Dachenko.
It's as simple as that. It's as simple as that.
What's the limiting principle on those constitutional provisions that can be read into 27B?
It will be the additional right for those disabled individuals. So
Well, that's the expansion. What's the limiting principle that lets it be limited to the disabled?
well, the fact that it will make it limited would be reasonably necessary. So the trial court judges are still gatekeepers to this statute. So they are still there in order to determine whether those expert funds that are allowed under 27A, I believe, will extend to those cohorts. So once they make that reasonably necessary determination, which this court has again set out number of factors that they can consider in order to come to that conclusion. So once they determine that, then that is a trial court judge's discretion in order to allow that. So again, there is a safety valve built into the statute. And then this court held the statute, construed the statute to apply, so then reasonably we can just follow the same guidelines as this court applied in Diachenko, with the trial judge as the gatekeeper, and read the wording of the statute to include funding for the experts, and then those fundings have to be necessary, reasonably necessary, and then once they are, then 27B and C will allow the disbursement of the funds, because it is to protect the constitutional right of a disabled person, which is constitutionally mandated. To that, I would say, if anything, Diachenko is amplified for people with disability because of the fact that their very chance of getting a hearing depends on these experts. Without these experts, as this court held in Crowell, the parole board won't be in a position to be able to evaluate and fulfill their commitment under the statute to see whether or not they can release these individuals with disability, with mental disability, to live in the society under the constraints and not violate the laws, and that whose release will be in compliance with welfare of the society. So for them to fulfill their statutory mandate, they need this. And this court held in Crowell that that is a modification. So again, I go back to my first argument saying this is very simple, and I submit this has already been answered by this court, is that by virtue of Diachenko and then later by Crowell and the funding statute that's been placed for quite some time, this is an easy answer, and it's already been answered by the court. Now, the other dimension to this that I submit will make this also a constitutional argument would be the Sixth Amendment, that once counsel is appointed to these cohorts, counsel is obligated to provide effective assistance. Counsel can't provide effective assistance because we are not trained to be social workers. At least this counsel was never trained to be a social worker or a mental health expert. So we will need the assistance of the appropriate experts.
A counsel only appointed in disability cases?
Yes, Your Honor. So then we will need those funds to be able to procure these experts, just like it was the intent of the legislature in 1974 when they enacted the statute itself, and it was the intent of this court, I submit, in other cases, such as Conseco case, where the court extended it. Now, granted, it was by statute and it's in the context of a 30B motion, motions for a new trial, but the spirit is the same. The intent is the same, where the court held where you are not constitutionally entitled to post-conviction proceedings, but in order to have a meaningful access, you need to have access to these funds, and then made the funds available under the same statute. So if we're looking at the intent of the statute and the intent of this court, in order to make so that the indigent cohorts will not be at a disadvantage, this is the very core of that, is that it will put them in a disadvantage because, again, their very chance to gain liberty is to have access to this funding, which is the purpose I submit. I see that I'm running out of time, but I would just give you this summary, is that we have the statutory scheme. We have the infrastructure that's in place through the Committee for Public Counsel. They have audit and oversight. They have been dispersing these funds since the 80s, and this court gave us the precedent in Diachenko and then Crowell to just follow the same reasoning and apply the availability and letting the trial court judges or authorizing trial court judges to approve these fundings under the statute. I'm happy to answer any other questions. If not, I see that I'm out of time, and I'll rest on my brief.
Thank you.
Thank you.
Okay, Attorney Yanuszewski.
Madam Chief Justice, and may it please the court, Andrei Yanuszewski, Assistant Attorney General for the Parole Board. I agree with much of what my sister just said in summary there, and Justice Wendland, I don't want to sprinkle magic pixie dust onto this statute, and I think that's why in our brief we've tried to stick with the plain language.
But the argument made by the parole board requires us to say that a criminal case is not final. That is, it remains pending through sentencing until the person is let out. And that just is inconsistent with all sorts of case law that I know of. I mean, the finality is, once the appellate period is over. At that point, DOC takes over, and it's no longer a pending case at all.
I understand that it may not be the most natural reading of the word pending, and it does butt up against precedent. This argument about the statutory language has never been made to this court. So part of what we are trying to do is show at a minimum that the language is ambiguous, and we can turn to some extrinsic sources here. But I think also the word pending should be informed by elsewhere. The word elsewhere that the legislature chose to use is extremely broad. In fact, I don't think they could have chosen a more broad word, and if they had wanted elsewhere to apply to the same, that second paragraph, which has never been cited in a case, if they wanted that to apply to the same set of circumstances as the first, they certainly would have said so. And so I think when you combine elsewhere and still pending together, you sort of get to a very broad application and reach of this statute. And of course, like as Justice, in a response to Justice Gaziano's question, he talked about we could just substitute Article 26 with the rights here at issue. We've tried to at least make a statutory text argument first. Of course, we could do that.
But let me ask you about being careful what you wish for. If that's the case, in the limiting principle for this situation under one proposal, is it applies to Dichenko defendants and it applies to people who have ADA concerns. As you read the statute, it applies to everyone seeking parole, correct?
I
So
think
now the Superior Court's going to be flooded with anybody who has a parole here in pending and they want funds.
so. I want to be
That's what my parade of horribles is.
to be as candid with the court of that as possible. I think if you interpret the statute that it can apply to parole hearings, that would mean anybody who is eligible for a parole hearing could seek the funds. But that does not necessarily mean that the funds are therefore available to that person. And so the judges, in their discretion, could deny funds to certain people if they don't meet a showing that the funds were actually necessary. I think in CPCS's amicus brief, there's some data about this, and it's maybe in the addendum, I want to say. I guess to that point, most of the requests have to do when there is a mental disability at issue here.
But think of how many people are eligible for parole, and why wouldn't you ask for an expert?
I certainly understand that concern, but again, I guess to avoid, or at least to go on as consistent with the statutory text as possible, I think that argument would have to, it would have to be available to everyone, and then the question would become, is there an actual entitlement to the funds thereunder? And then that's where we would argue based on the protections in the law for people with mental disabilities, as well as this court's decision in Crowell. Because if we don't come up with the answer to not go in this direction in this case, the court's words in Crowell, although they were dicta, sort of become toothless.
So the way you would write the opinion would be to say that elsewhere pending is given this broad definition that pending usually doesn't get. So there's a statutory basis for this. We don't have to contort the statute. And then when we give guidance as far as Superior Court goes, so they don't throw things at us, we say, well, in instances of mental disability, for example,
Yes.
and then that would comport with the ADA.
Yes, Your Honor. Yes, I mean, there of course is, as this court did in Diachenko 2, it held it was just appropriate to construe the statute in this manner. There are certainly constitutional and statutory rights at issue here, as there were in Diachenko. They're not exactly synonymous, but or exactly analogous, but of course the court could do more of the Diachenko 2 type of analysis as well. Just tried to provide as much of a basis for the court to do it through the statutory text as possible in this case. And I think by doing that, you can talk about the purpose of the indigent court costs law. Nothing about either the legislative history that I could find or sort of the purpose of the statute was really to make it narrowly construed, or it's really to expand access.
Except the language of the statute itself, right? Which is usually where we start for statutory construction.
Absolutely.
And what happens to our canon of statutory construction that talks about when you go to the specific to the general? I mean, you focus on that elsewhere, but if you look at the words that precede that, they're talking about courts.
And I understand there's precedent from this court that says these statutes have generally applied to court proceedings. I understand that's what the language of the statute says, but there's a lot of general kind of language in some of those cases that, and I think in Diachenko 2 did not come up with a holding that said the funding statutes could ever be applied in this manner. And so I'm certainly not arguing that a parole hearing is a court proceeding. Of course, I wouldn't argue that under the statute, but I think it's so closely connected. I cite a couple of cases where, at least in Diachenko 2, I think footnote 12, the court said parole is a component of the original criminal sentence. There's some federal case law that says it's extremely, essentially closely connected. And so the only time, of course, we'd look at the purpose of the statute and the history and sort of some of the legislative developments, assuming the court finds the language ambiguous. If the court thinks that the language is unambiguous, then we would make the Diachenko 2 argument and just say it's appropriate to construe the statute in this manner when the constitutional rights are at issue.
Can I ask you a sort of practical question? How do these motions for expert funds come to being? Is there something, a complaint filed in the nature of certiorari as there was in Crowell? Or is this like sua sponte, just a motion suddenly appears on the docket of the Superior Court?
I think it's the latter, Your Honor. Like in this case, once the parole board referred Mr. Hastings to CPCS and an attorney was appointed, a motion was filed, an ex parte motion for funds. The Commonwealth, they're not appearing here today. They're usually not involved at all with these proceedings.
Is it like under the criminal docket number then?
It is. It is. It did come up on the criminal. I'm almost positive of that.
This all arose post-Crowell as a mechanism for funding, basically.
Yes.
And then, as we saw in this case, some judges allow, some don't.
Exactly. We had one judge and this,
The
exactly.
Judge Mulqueen allowed, and Judge Wilkins
Exactly.
said no.
Exactly. And so, I mean, I think.
But if you construe that motion as in the nature of certiorari, then the statute does read on all fours on this, because it's the commencing of a civil action in any court. And I'm wondering if the parole board has given any thought to that construction, which would be consistent with our statutory canons of construction.
I have not, I will be honest, I've not considered that, Your Honor. Just given the way that the motion for funds came in this case, it wasn't an area that I looked into at all. I would be happy to look into it and provide the court with anything in writing.
But just because it strikes me as Crowell was in the nature of certiorari, so it is a civil action.
But it was
it was post-parole denial, but
right,
yes.
And a complaint against the parole board. Whereas in this case, we have just a motion was denied. A motion for funds was denied, on the criminal docket. And then the judge, Judge Wilkins reported the question, but it's not.
But isn't it in effect a complaint against the parole board because they don't have the funding and this is constitutionally required, and so parole board, you need to come up with the funding, and then you start the civil action, and under 27B, you get the fees.
That sounds like an excellent interpretation of the statute, Your Honor. I did,
hadn't
that I
thought
wish I
about
had
it.
considered.
Thank you.
I appreciate it very much. I don't need to necessarily belabor the points about the constitutional protections. I think we're all certainly well aware of them, and of course, we're not attacking Judge Wilkins' findings here that the parole board doesn't have the structures or the mechanisms to effectuate this result, which I think just makes so much sense in cases involving prisoners with mental disabilities. And so, especially in Crowell, and I think it was in footnote 16, you talked about how essential it would be and how to have an expert's assistance, and it would be difficult to imagine how the board could proceed effectively. Of course, that's case by case, and every case could be a little bit different, but I think the general point is that it's very important for the board to have these funds in order to make the best, for the board to have the report and for prisoners to have the funds for the board to make as good of a decision as they possibly can. And they certainly minimize the risk that prisoners with disabilities will be discriminated against